And let me make it very clear here. I said that as far as I'm concerned, I want Lula to die. I'm not preaching violence, but I'll be honest. If he has a heart attack, I'll be happy. If he has a stroke and goes straight to hell, I'll be happy.
It's just that currently in Brazil, we are seeing many people, many groups confusing the exercise of rights with the abuse in the exercise of rights. These are completely different things. And one of these confusions is exactly what's happening here. Parliamentary immunity. And just look at the historical background of parliamentary immunities, which in the way we know them today, obviously with some changes, arises in the English Parliament. Parliamentary immunity, substantive immunity, the protection of speech, votes and opinions, it arises to allow the parliamentarian to perform his function. Since Rui Barbosa, here in Brazil, in habeas corpus rulings before the Supreme Federal Court, it was already stated that substantive immunity, inviolability, is not a privilege of the parliamentarian. It is a right of the legislative body. Rui Barbosa, quoting the greatest constitutionalist, or one of the greatest constitutionalists of the empire, Pimenta Bueno, stated exactly that. It is not a privilege. It is a provision, a guarantee for the proper functioning of parliamentary and legislative juries. Substantive immunity, parliamentary inviolability, was not created to offend people, to attack people. It was created to discuss issues. It was created to oversee the other branches of government, and eventually, in the heat of the discussion, any excess, that excess would be set aside. But not so that people could commit crimes under it. Today, and not just in this case, but in countless cases, we see that lawmakers arrive in Congress and start offending people. Some commit racist acts, others commit misogynistic acts. And then they say that the Constitution in Article 53 guarantees this. It does not. The Constitution does not provide for this. And this Supreme Court, this federal Supreme Court, as the distinguished rapporteur rightly pointed out, this federal Supreme Court has been gradually analyzing and establishing actions regarding material immunity. Based on the existing theories, I cite, in my opinion, a wonderful work by Professor José Levy. In fact, it was Professor José Levy's habilitation thesis at the University of São Paulo about material immunities, in which he discusses this evolution of two major theories, Blackstone's theory and Stuart Mill's theory, about immunities. One, the first said that any word spoken within the English Parliament would be covered by immunity. But obviously, the reality in England in the 19th century was that people didn't insult each other. And another one, as Stuart Mill said, that there would need to be a causal link with the function performed. And these theories, over time, they started to blend together to establish that not only inside Parliament, in our case, the National Congress, but even outside, in an interview, on social media nowadays. But if there was a connection with the parliamentary function, it would be covered by immunity. There's no connection. No existing connection with parliamentary activity. This so-called geographic clause, location clause, doesn't matter. What matters is the connection, the causal connection. And the eminent Justice Carmen Lúcia, I'm not going to repeat it, has cited several precedents from the Federal Supreme Court here in this sense. What doesn't seem to me is that in a discussion, actually, on three separate occasions, as the rapporteur said, first, the Public Security and Combating Organized Crime Committee, then on the House floor, and then selecting, unfortunately, if Your Excellency was a parliamentarian in both houses, you know that today, countless parliamentarians only care about social media likes. So they curse, then record with some aid recording, and then leaves the House floor, makes edits, and publishes. So there are three different moments in which the parliamentarian offends. Pop utters insults to the President of the Republic, partner in crime and disgrace. I want you to die. Not even the devil wants you. Go to hell. Imagine if Blackstone and Stuart Mill in the English Parliament thought about this possibility. That's why some people have no idea when they refer to foreign studies from the 19th century to justify this absurdity we live in today. That would be unimaginable. In fact, the parliamentarian would be expelled from the English Parliament on the spot. But here, instead of dealing with public security and organized crime, it's just insult after insult. I really do want him to die. And even the current president's illness is brought up here. It's extremely offensive and low. Nothing is covered by immunity. So I immediately reject the immunity defense, which is their main defense argument. That's for rejecting the complaint. There is a second argument, also addressed in detail by the distinguished rapporteur, provided for in Article 140, Paragraph 1 of the Penal Code, which would be immediate retaliation. In other words, the judge may choose not to apply the penalty when the offended party directly provoked the insult. And the case law really has been emphasizing this possibility, that in this case, the Penal Code only addresses the application of the penalty, but the case law, besides the light, the air, everything dried up here, Mr. President. This Hollywood-style lighting that Your Excellency ordered, so the image would look better on Justice TV. Article 140, Paragraph 1, Item 1, has read the case law to admit that from the outset, upon filing the complaint, so that the criminal prosecution does not even begin, it's the judge, or in our case, the panel, who can recognize it. But here it's very clear. It says, when the offended party, in a reprehensible way, directly provoked the insult, the defense comes and says that another congressman supposedly said it. The other congressman was not offended. So, this defense argument is not reasonable at all. In the same way, we know about the independence of the different spheres. The fact that it was dismissed by the Ethics and Parliamentary Decorum Council does not affect the criminal proceeding, in our case here, for the acceptance of the complaint. Setting aside these three initial defense arguments, I agree with the distinguished rapporteur that the requirements for accepting the complaint are present here, as provided in Article 41 of the Code of Criminal Procedure, as well as the existence of sufficient basis, Article 390, Item 3. There is evidence that the offense occurred and sufficient indications of who committed it. And here, the conduct fits the offense definition and remains punishable because there is no basis barring punishment. Therefore, Mr. President, I fully agree with the distinguished rapporteur accepting the complaint filed against Gilvan Aguiar Costa, also known as Gilvan da Federal, for committing the crimes alleged by the Public Prosecutor's Office.